Good. First, can everyone see and perhaps more importantly hear me? Yes. Good. I think everybody can. Good. Well, thank you for joining. One of the reasons is, of course, to make sure that the hearing next week is effective and completed in the available time. So we sent around a list of items that hopefully we'll be able to clear away today, and then have a good clear start next week. Mr. Rowett, the first item is the fifth affidavit of Mrs. O'Neill Morton.
Yes, Commissioner. Before I just respond on that, could I just introduce for the transcript the representation today? We have, on behalf of the Attorney General and the elected ministers, Mr. Edward Risso-Gill and Ms. Sarah Jane Knock. On behalf of remaining members of the House of Assembly, we have Mr. Richard Rowe. And today we have Mr. Alex Hall-Taylor, who is here to, or has been permitted to represent the governor when he comes to give evidence on the 24th of November. Everyone is attending remotely. To return to the first matter on the agenda, and just to give some background, Commissioner, Dr. O'Neill Morton, as you'll recall, gave evidence on day 44, which was the 5th of October, 2021. And subsequent to that, on that day, the COI emailed the Attorney General seeking disclosure of certain information related to the response of the Office of the Premier to the evidence in the reports of the Auditor General and the Internal Auditor. You recall that that was a document which the Premier's office prepared independently and submitted to the Commission. The request was still outstanding at the time of the directions hearing of the 22nd of October, and you made directions in relation to responding to that request. And that was to be done by the 29th of October. With the grant of an extension, what occurred on the 1st of November was that rather than just documents being disclosed, as the inquiry had originally requested, we received the fifth affidavit of Dr. O'Neill Morton together with exhibited material. Subsequent to that, the COI wrote to the Attorney General explaining that that required an application, and that application was then made, and to cut through it, that is the issue that I think remains outstanding in relation to the affidavits submitted on behalf of Dr. O'Neill Morton. You have a written application dated the 5th of November 2021 from Mr. Nicky Olympitis of the IRU, submitted on behalf of the Attorney General. And it's that matter. I think it may be that there are questions that you wish to ask of Mr. Risso-Gill, but unless I can assist further, I'll turn the microphone over to yourself, Commissioner.
No, thank you, Mr. Rowett. Mr. Risso-Gill, we now have this affidavit, 4 pages of affidavit raising some new matters, because I think Mr. Gaskin hadn't been referred to at all in the evidence up to the date of this affidavit as having any role. This evidence says he had quite an important role, and an exhibit of about 2,000 pages. Only one question, I think, there, Mr. Risso-Gill. For the 24th of November, we've been told that Dr. I think I said Mrs. before, Dr. O'Neill Morton is not available. Can I explore slightly why she can't be available to answer any questions?
I will need to take instructions about that, which I will do immediately now. I don't have instructions as to exactly why she's not available, or certainly not in front of me right now. So those that It may be that Ms. Knock can help with that. I'm not sure. Forgive me. Yes, so I'm now assisted. We've been told that she is in fact out of the territory. I don't know to what whether that precludes it. That's the extent of the instructions I've now received. Whether that means she couldn't possibly join remotely, I don't know whether that's been explored yet.
No, thank you, Mr. Rusogil. That reflects what we've been told, and that is that she's out of the territory. But that doesn't obviously preclude her attending and giving evidence remotely. I don't think any evidence that she would need to give would be very long, but perhaps you could take instructions on if she were available to give evidence remotely if required. As I say, that rather curiously, this evidence does contain new material, which, despite several days of evidence on this topic, had not been disclosed before, and therefore it may be helpful if you were able to give evidence next week. So could you perhaps take instructions during the course of the hearing as to whether that might be possible? Excellent, thank you very much.
We're certainly going to try and do that, so yes.
Good. Otherwise, I think it's simply, I will allow this evidence in, the affidavit in, and I will obviously make of it what I can, with or without Dr. O'Neill Morton's further assistance at an oral hearing.
We're grateful, sir.
Good, thank you very much. Next, Mr. Rawat, Mr. Frett's further affidavit.
Yes, Commissioner, you'll remember that when the governor came to give evidence in October, part of his evidence related to training budgets for the civil service. And at that point, Sir Geoffrey Cox, who was there on that day to represent the interests of the elected ministers and also represent the Attorney General, indicated that he would seek to adduce evidence in relation to what came to be described as the public service budget. You gave on the 22nd of October at the directions hearing, you made an order that any such affidavit evidence should be produced by the 29th of October. That was your initial proposal. But Sir Geoffrey asked for and was given until the 5th of November. One of the points that you made, Commissioner, is that you would need to see the affidavit before deciding whether to accept it. Those directions having been made, and that essentially Sir Geoffrey's request for time until the 5th of November having been granted, that was enshrined in order number 23. But however, on the 3rd of November 2021, the attorney sought an extension to the 12th of November. Reliance was placed on the need to prepare the budget, and that the Ministry of Finance had been working not only with its usual workload, but also to deal with requests from the COI throughout the year. However, I should make the point that at that time, there were no outstanding requests from the COI to the Ministry. And this affidavit was one that was not requested by the COI. It was upon the submission of Sir Geoffrey. You, Commissioner, then granted an extension till the 10th of November. And the point was made that because it went to public service budgeting, it would be important to give the governor sufficient time to consider its contents before he came or returned to give evidence on the 24th of November. The COI also wrote on the 5th of November to the attorney seeking further information about who was going to make this affidavit. And in fact, it wasn't until the 8th of November that it was confirmed that it was Mr. Frett. But what you had also allowed on the 7th of November, you granted permission to share part of the governor's response to a warning letter with Mr. Frett. So it would seem that between the 22nd of October and the 7th of November, Mr. Frett, who was due to make the affidavit on public service budgets, hadn't seen the governor's response. But the position we came to was that on your direction, Commissioner, this was due on the 10th of November. On the 11th of November, the IRU wrote to the Commission to say that they would not be able to provide the affidavit, quote, today, end quote, as they had not received a signed or approved copy. There was no application at that time for an extension of time. The affidavit was provided on the 12th of November, and in that email, the IRU again pointed towards the demand of preparing for the budget, but added that, quote, we hope that the Commissioner will find the affidavit of assistance and respectfully request an extension of time until today for the provision of this evidence. The affidavit itself is 17 pages long. It has 4 exhibits running to 84 pages. There has been no application for any part of it to be redacted. And so the issue that you have to determine this morning, Commissioner, is to decide firstly whether to allow what appears to be a retrospective application for extension of time to submit the affidavit to you for consideration, and then whether to in fact admit it with its exhibits as part of the record of the inquiry.
Yes, thank you very much. Mr. Russo-Gill, plenty of new stuff in this affidavit as well, but Mr. Frett is available next week and is due to give evidence, and he can be questioned about this affidavit then.
Yes. In terms of new stuff, I hope at least Sir Geoffrey did presage the initiative, which is the first section, and public service, well, budgeting as well. So I hope that the topics, at least, don't come as too much of a surprise.
No, the topics don't come particularly as a surprise, just all of the new evidence that goes to those topics. But despite the lateness of it, and again, there doesn't seem any sensible reason why this evidence is so late, I propose to allow the affidavit in. I assume that there are no redactions. So I'll simply say that this is open for public consumption, both at the hearing and in the report. And Mr. Frett can come next week and answer any questions in relation to it. Is that all right, Mr. Russo-Gill?
We're very grateful, sir.
Yes, thank you very much. Next, I know there's been developments in the last few hours on this. The public interest immunity application on the National Security Council material. Mr. Rawat.
Yes, Commissioner. If I could just take this shortly, if I may. You will recall that there have been, in the past, 2 purported applications based on PII in relation to material that emanated from the National Security Council. On the 22nd of October, you gave further directions in relation to those applications. And in effect, any application for PII in relation to material contained in the EZ shipping bundle, and you'll recall that we had to do those hearings, at least in part, in private, or contained in annexes to the response of the elected ministers to the position statement of the governor, was to be made by the 5th of November 2021. The application also came to encompass the transcripts for days 50 and 52. Again, the attorney has needed an extension of time to deal with this matter. As I understand it, it is not a matter on which the IRU or Withers are instructed. And so neither Mr. Russo-Gill or Ms. Knock would be in a position to address you on this matter. Where the developments that there have been is that the application has been submitted. It was followed yesterday evening with a bundle or bundles of the documents which are the subject matter of the application. and also confirmation that there are no redactions sought in relation to the transcripts. In those circumstances, I think what I would invite you, Commissioner, to direct now is that, or to observe at least, that the next step should be that you and your team will need to consider the application, but that you should make a direction that the attorney should ensure that she's available on the 24th of November in case there is a need to canvass this matter at a hearing.
Yes, thank you. Now, Mr. Risso-Gill, this is something you can't help us on because you're not instructed on behalf of the NSC, nor can you be. I think three things.
Sorry, the only thing I should say is I could help on the law, but it doesn't sound like that's necessary. Well,
no, and if you've seen the various applications that have come in, it may be that you could help the AG on the law and how these applications should be made. But just leave that to one side for now and look at this particular application and where we are on it. In terms of the transcript for days 50 and 52, it's taken a month for the attorney to get back to us, only to say that, in fact, they can be made public and no redactions are being sought. That is something which I would have thought could have been done in a matter of minutes, if not hours, when the transcripts came through a month ago. But in any event, those transcripts can be now made available to the public in full, and we will put them up onto the website. In respect of the bundles of documents, as Mr. Rowett hinted, I think, what I propose to do is to making what I can of the applications that have been made, and will come to a view on redactions, which of course is ultimately a matter which I have to do on the material that we have. So nothing else further is required, except, and I think Mr. Rowett is right in this, we will need on the 24th someone who can speak to the redactions in case there are any issues. We only got this material, it was at 11:15 last night. I'm afraid on my machine I couldn't work out whether that was BVI time or UK time, but in any event, it was very late. We will need to consider it. If there are any issues, then we'll need to go into closed session on the 24th and deal with them. But I'm hoping that there won't, and that we can deal with all of the redactions on the material that we have. But I will direct that the Attorney General appears next week on the 24th by way of someone who can represent her in respect of the NSC applications. There's nobody here today that can do that. Does that clear up that, Mr. Risso-Gill, so far as you're concerned?
The only thing I should point out is the Attorney General is taking instructions directly from the Governor on this, and plainly I'm not in a position to take instructions as to whether the lines of communication will be sufficiently open for necessary instructions to be taken between now and next Wednesday on the matters you may or may not raise. And I am asked to emphasise that if there are issues relating to the specific redactions, and you do need to write to anybody, that should be addressed to the Governor via the Attorney General. But beyond that, I don't think I can help any further.
I mean, the issues about redactions of the NSC material has been going on for literally months, and it's not an issue. It is not an issue that I'm prepared to allow to delay preparation and delivery of the report. You say that the Attorney General is taking instructions from the Governor. That's obviously a matter that you may know, having been instructed by the Attorney. But if that is right, I am due to deliver my report to the Governor. And so if there are any redaction issues in relation to wider publication, they'll have to be dealt with at that late stage. But so far as I'm concerned, I'm afraid that we now need to press on with getting this report written and delivered. So far as the immediate issues are concerned, we will do what we can in relation to the documents that we have. I would be very surprised if we needed to or wanted to refer to anything that could possibly be covered by PII in the report. But if there is, then we'll try and raise that before next week's hearing. Is that okay?
I'm very grateful again, sir.
No, thank you very much.
Commissioner, can I just make one point on that? I think Mr. Risso-Gill says that this is the attorney's taking instructions from the governor. I think, to be more accurate, she's taking instructions from the National Security Council, which includes the governor, the premier, and the deputy premier. The difference, and this was a difference that was only highlighted when the governor gave evidence, and that is that the NSC does not instruct the IRU, which is why, helpful as Mr. Risso-Gill's submissions always are, and they may well be on the law in this area, there is a line beyond which he cannot cross, and he is as aware of that as I am. But as you say, hopefully, and it may involve discussion between the COI and the Attorney General's chambers, this is a matter that need not trouble you on the 24th of November.
No, hopefully that will be right. And I'm fairly optimistic that that will be the case, Mr. Rowett. Good. The next issue, I think, is the scope of questioning for the governor next week, Mr. Rowett.
Yes, Commissioner. You had directed on the 22nd of October that the attorney set out those matters on which she would wish to question Governor Rankin, you having agreed in principle to his returning to be questioned. Subsequent to receipt of a list of the areas on which the attorney wished to question the current governor, the COI wrote to the attorney and asked for further clarification of those matters, and a response was sought and received by the 8th of November. The Commission has shared that information with the governor so that he is aware of it, and it may be that Mr. Hall-Taylor may wish to address you on this. But the question that you, or the issue that arises for your consideration today is the extent to which questioning of the governor will be permitted on the 24th of November.
Yes, thank you, Mr. Rowett. Mr. Hall-Taylor, you may well want to speak to this. At the moment, what we've got is this. We've got 5 pretty wide areas that have been identified by Sir Geoffrey Cox for the attorney, in respect of which he wishes to ask questions of the governor. Secondly, we have a time limit of an hour for his questions. And given the business of the day, that is something I've made clear to him. It will be important for him to comply with. It seems to me that in the absence of any greater particularization of the areas, there is a risk that the governor will not be able to respond to questions because he will not have had time to prepare for them, including reading the particular documents which relate to the particular questions. But of course, we don't know what the questions might be. But at the moment, it seems to me that the main constraint on questioning is one of time as opposed to topic. Mr. Hall-Taylor, any submissions to make on this?
So only to agree with you that at the moment, this scope of questioning seems to be particularly wide. Each topic themselves could take up quite a considerable period of time. And the governor obviously is seeking to prepare to assist the Commission as far as he's able to do so. We would naturally encourage some narrowing down of both the issues and perhaps the topics themselves, but perhaps even specifying the actual areas within those topics that might be of interest to Sir Geoffrey and any documents that he intends to refer to in advance of the 24th of November, so that the governor can properly prepare and assist the Commission as best he can on the day.
Thank you, Mr. Hall-Taylor. Mr. Risso-Gill.
Yes, sir. I hear what everyone has said, and I've not yet had an opportunity plainly to canvass that, nor will Sir Geoffrey have had a chance to hear it. However, I now have, and the only thing I would say immediately is that there is some further clarification in the document produced on the 8th of November. Particularly, I'd refer to question 5 and a little more specificity which was given to the places, at least in the governor's own evidence and in his response, which had given rise to the headings that we point to there. But I hear what's been said about further specificity, and I can take that back, as it were.
There's not much more I can do, I don't think, Mr. Risso-Gill, other than make 2 points, which I will make. Firstly, there is the time point. I am not going to allow this questioning to go beyond the hour which I think Sir Geoffrey asked for, and certainly it's the time that I'm allowing him. So he has to be pointed with his questions. The second thing is, it seems to me it would assist if Sir Geoffrey and you considered carefully if you could give any further direction in relation to the questions that you might want to ask the governor and documents you may want to refer him to, simply so the evidence that he can give next week can be as focused as possible and can be as helpful to me as possible. And can I ask you to write both to the COI and to Mr. Hall-Taylor by Friday at noon with any further focusing on topics and documents that you can, that you are able to give us. That, I think, would be helpful.
I should immediately, I think, flag that I'm not sure that Friday will be possible. May I ask that we do that by Monday?
Well, Monday's better than later.
As soon as possible, plainly, if it can be achieved earlier, but I know realistically there may be difficulties with Friday.
Okay. Firstly, Mr. Risso-Gill, and I don't say this pejoratively, but directions to do things as soon as possible in the past in this COI have not been helpful and have not been complied with. So can we say Monday by 10 a.m.?
Thank you, sir.
Yes, and then that will help my preparation, but it will also, I hope, help the governor to a certain extent. Good.
Commissioner, I wonder if Mr. Risso-Gill could give an indication now as to whether the governor may be questioned on the contents of Mr. Frett's affidavit. Because if that is there, then that's at least an indication to the governor of something that has emerged since the 8th of November on which he may be questioned.
Yes, I'm grateful to my learned friend. That, of course, now that that has been allowed in, I'm helpfully reminded by my learned friend, effectively, that that does constitute some further specificity which we didn't have before. Now that you've allowed the application to put in Mr. Frett's affidavit, yes, the answer is there will be questioning on the basis of that affidavit, so on the basis of the evidence within it. So that, I hope, also provides a good deal more, in fact, specificity as to the areas of question.
Good. Thank you, Mr. Rawat. Thank you, Mr. Risso-Gill. Anything else on this topic, Mr. Rawat?
No, thank you, Commissioner.
The next we move on to closing submissions, and first Silk Legal's closing submissions. Mr. Rawat, do you want to briefly to outline where we are in respect of those?
Yes, Commissioner. On the 22nd of October at the directors hearing we held on that day, you directed that Silk Legal should, by the 29th of October, lodge a list of those matters upon which they intended to, or they would like to make closing submissions. You also directed that they should, by the 26th of October, file any written submissions concerning the Seacows Bay project, which is a project that involved, as Minister, the Honourable Julian Fraser. Silk Legal did not comply with either direction. In the absence of any information, the COI's press notice, which notified the public of the date of the hearing, noted that Silk Legal hadn't complied with the directions concerning closing submissions, nor applied for an extension. And so that they would not be making oral submissions. What almost immediately followed was what purported to be closing submissions. And these, whilst apologising for, quote, missing the deadline for filing final submissions, give no explanation as to why it was missed, nor do they make an application for an extension of time to comply with the order. And in those circumstances, the question that arises and on which you may wish to hear from Mr. Rowe is whether indeed he wants these submissions to be put before you.
Okay, thank you, Mr. Rowe. I hope anyway, we can deal with these shortly. The submissions were late. There is no application to rely on them. What I propose to do is to extend time. I will take them into account. You're not making an application to make oral closing submissions, and those are the directions I'd propose to make, Mr. Rowe. I don't see at this stage of the COI there is any benefit in exploring why this deadline, like so many other deadlines, was missed.
Thank you. Good morning, and thank you very much, Commissioner. We agree with you entirely.
Good. Thank you very much, Mr. Rowe.
Further wish to add to this?
No. Thank you.
So it's been treated as received, Commissioner. Is that correct?
Yes, we'll take them into account. I'll take them into account, and that's that. The Attorney General's closing submissions, Mr. Rawat, that's more substantial, I think.
Yes, the attorney had the same direction to lodge a list of those matters on which she wished to make closing submissions, which she did do. But that was on the 29th of October. And at the same time as doing so, there was an application for an extension to the 29th of November to provide closing submissions. You'll recall, Commissioner, that the order asked for any closing submissions to be submitted by no later than Friday, the 12th of November, if allowed. And that was with the agreement or without any issue being raised by Sir Geoffrey. So we had an application on the 29th of October for an extension of time till the 29th of November. That was refused in a letter from the COI dated the 5th of November. It was renewed on the 11th of November. Again, the extension being sought being to the 29th of November. And that was refused in a detailed letter from the COI on the 12th of November.
Mr. Rawat, my apologies entirely for interrupting, but we've lost Mr. Rousseau-Gill.
Oh, yes. No, thank you, Ms. Knott. We do seem to have lost him.
I think we lost him
pause
before you started speaking on this topic,
okay.
Mr. Rawat.
Well, firstly, let's try and get him back, and then Mr. Rawat can rewind in terms of the introduction.
We'll do what we can. Apologies.
Sir, I do apologise. I'm very sorry for the delay, sir. My computer just died for some reason. Anyway, I'm back on now.
No, thank you, Mr. Rousseau-Gill. Did the computer die? And these things happen, I'm afraid. And thank Ms. Knott for noting it and letting me know so that we can get you back, and we've got you back. Did you disappear just before Mr. Rowett was about to begin?
If we'd reached item 6 on the agenda, yes, I'm afraid so.
Yes, good. No, thank you very much. Mr. Rowett, can you just rehearse that?
Yes, Commissioner, in compliance with the order that you made on the 22nd of October, the attorney did lodge a list of those matters on which she wished to make closing submission, and she did so on the 29th of October. At the same time, however, she made an application to extend the time by which closing submissions should be submitted from the 12th of November to the 29th of November. That application was refused in a letter from the COI dated the 5th of November. On the 11th of November, the attorney, through the IRU, again sought an extension till the 29th of November. And the basis of that application was addressed in detail in a letter from the COI dated the 12th of November, in which it was made clear that you did not see force in the basis of the application, but were prepared to extend time for submission of any closing submissions to the 15th of November. On the 15th of November, the COI received an email from the IRU explaining that the attorney would not be in a position to provide written submissions today, maintaining her request for an extension of time, and then concluding that in the circumstances, we will respond to your letter as soon as we are able. And so that's the position we've reached. A letter was sent from the COI yesterday, which explained that the application for an extension of time had been refused, and that at present there was no application before you for further time. And so the position that we've reached is that the attorney has not complied with the direction to submit her closing submissions by the 15th of November.
Good, thank you, Mr. Rowett. Mr. Rousseau-Gill, so far as I'm concerned, this is not simply a matter of the attorney and the IRU ignoring directions, which I'm afraid has happened on a very regular basis and has been disruptive. But this is slightly more pointed here. The directions that I gave on the 22nd of October made clear that on the day that was going to be identified for the cross-examination of the governor, I would hear final oral submissions, and they would be based upon written submissions which needed to be lodged before that hearing, and indeed in good time before the hearing, so that the oral submissions could be very focused indeed. In fact, hopefully, they would be really restricted to Sir Geoffrey, in your case, responding to queries that I had about them. And that was clear on the 22nd of October, and that is the plan that we've been working to. In fact, the cross-examination of the governor is somewhat later for various reasons, somewhat later than I'd hoped it would be. But nevertheless, we still haven't got any submissions from those the Attorney General represents. We still haven't got an extant application. We still have no date when we might expect them, and certainly no date before the 24th of November, which is vital if there are going to be any oral submissions, closing submissions at all. With that background, have you any submissions to make?
So I'm not applying today, and we're not applying to make oral submissions. In respect of the written submissions, what I can say is that I anticipate being in a position that we'll be in a position to make an application to put them before you by 4 p.m. on Monday. But it won't be before then. And I can expand a little on why, if that today would be helpful.
Mr. Rousseau-Gill, I'm sorry to interrupt, and it's quite difficult to interrupt remotely, but could I just interrupt to make sure that I've understood what the what you've said so far? Are you saying that it is proposed to lodge written submissions by the close of play on Monday?
That is what I anticipate the application will be for in due course. An application that you accept them on Monday rather than on next Monday, rather than the Monday past. But that's not an application that has been made. I accept that. And it seems that there is little point in making such an application until we have the submissions to which that application would go. So that is why I phrase what I have said in the way that I have.
Okay. It's certainly very unfortunate. As I say, the original proposal for closing submissions was based on the premise that I would have an opportunity to raise queries about the closing submissions if, as I expect I may well have, if I had any queries to raise. And it will be very unfortunate if I'm robbed of that opportunity. But as you say, Mr. Rousseau-Gill, there currently is no application for me to consider. When the application comes in, I will consider it. Making any directions today would be pointless.
In those circumstances, sir, can I take it that it wouldn't be a useful expenditure of time now for me to help with why we are in the position we're in, or give any?
No, Mr. Rousseau-Gill, you've written at length to the IOU, have written at length of the reasons for the delay. I'm afraid I don't find any of the reasons compelling, and I don't think it would be helpful to hear any further submissions today. What I'm anxious to do is see any submissions that the elected ministers have, and as you say, at the moment, there is none prepared. When they are prepared, you'd have to make an application, and that can only be considered on its merits. If the application is to lodge them after the hearing, then I'm afraid that's very likely indeed to be refused. But you say the application is likely to be that the submissions will come in by the close of play on Monday.
This at least I can say, sir, a very great deal of work has already gone into them. There is a very substantial draft already being worked upon. The work has been done on all the three questions we alerted to, certainly particularly the first two of those questions, directed to the topics about which you've heard during the course of the inquiry. So it isn't as if, it's quite the opposite of people sitting on their hands. As I say, the work of going through the material, extensive as it is, has been taking place. And that is why I'm able to at least to indicate that we hope to be in a position to apply for you to receive submissions on Monday.
And Mr. Rousseau, can you give me this further comfort? The direction is for that the submissions will be limited to 20 pages and not include any evidence. Can you give me an assurance in respect of that too?
I think I can assure you that if there is any evidence at all, it will be very limited. And in terms of the length, we've borne very carefully in mind the direction as to 20 pages. I can't promise that we may not go over that, but we will try very hard to keep as close to 20 pages as possible.
Well, there we are. I'm not sure that we can say any more, Mr. Rousseau-Gill. When the application comes in, I'll consider it.
Thank you, sir.
Anything else on that, Mr. Rawat?
No, Commissioner. Thank you.
The redaction process, I think, is next to be considered, Mr. Rawat.
Yes, Commissioner. I mean, again, redaction is a matter that has been something that has not gone as smoothly as the Commission expected it to be. There has been a difficulty persuading participants to comply with the protocols and to comply with request to produce documents in certain formats. There's no real benefit in going into the detail of that history, but you made clear on the 22nd of October that you would take steps to ensure that those documents that to which you wanted to refer to in your report would providers of documents would be given one final opportunity to respond as to whether they were seeking redaction. The process has been sent to the attorney in an outline to explain the process that the Commission intends to take. There has been correspondence, but we would say that the process is clear. It's important that it be adhered to, and in particular, it's important that paragraph 9 of your order made on the 22nd of October be adhered to, and that is that responses are made within 5 days, because what we cannot allow is any ongoing issues over redaction delaying the preparation of the report.
Yes,
and so I think it's just a question of making sure that that everybody here today is clear as to the approach that we intend to take.
Thank you. Mr. Rousseau-Gill, redactions have been an ongoing problem. And the Attorney General has reserved her position, reserved the position of the elected ministers in respect of a number of areas, including, if not wholly, in respect of most of the documents that have been disclosed and even referred to in hearings, whether they can be referred to in the report for general publication without any further reductions. So she reserved her right to come back to me in relation to reductions before documents were referred to in the report and published with the report. Although that was not in compliance with the protocol, it was something that I was prepared to live with, but I made it clear that it would mean later that there would be a considerable amount of work for the RU to do, and it would be under very considerable time pressure. That's not my fault. It's because the protocols were not complied with. And that moment, I'm afraid, has been reached now. The process, as you know, Mr. Rousseau-Gill, is that we will notify the attorney of documents that I propose to refer to and rely on in the report, and give her a final opportunity to make submissions, make an application in relation to any redactions from those documents that she thinks should be made before the documents are published as effectively an addendum to the report. I've given 5 days for that. In some ways, so far as the work I am doing in drafting the report, that is extremely generous. But after those 5 days, I'm afraid, the report producing process will move on, and we will simply not be able to take into account any submissions or application the Attorney General wishes to make late. I will develop a plan for dealing with redactions in these documents for the purposes of the report as best I can on what I have. So any observations on that, Mr. Rousseau-Gill?
None from me, sir, but I will, if I may, hand over to my learned friend, Mrs. Knock, who might have, I'm not certain, but might have some observations, because this is very much an area on which she has spent a good deal of time.
Okay, thank you very much.
Thank you, Mr. Rousseau-Gill. I think we'd like to say thank you very much for setting out your protocol for the redactions. That's very helpful. The only thing we would like to ask is that to avoid slippage and to comply with your timetable, given that we have already applied redactions to documents that, or proposed redactions to documents that appear in hearing bundles, we need to know when you are sending the documents to us whether or not those documents have appeared in a hearing bundle, and if so, whether or not redactions were applied. That will enable us to comply with your timetable?
Mr. Rawat.
It's not a question I can answer straight away, Commissioner. I will need to speak to those members of the team that have more involvement in this process than I do. What we are trying to do in order to avoid slippage is not, for example, send to the attorney an entire hearing bundle, but rather to focus on those documents that are of direct interest to the report. And so when we may be delivering them in a different way, but I think what I can say is that I will ask to what extent we can comply or assist Ms. Knock with her request, and do what we can to kind of facilitate that.
Yes, thank you, Mr. Rawat. I mean, Ms. Knock, the number of documents, I mean, compared with the hearing bundles, will be very few. Some of the documents might be quite big, but the documents will be very few. To the extent that we can assist in whether they've appeared in hearing bundles, we will. But the attorney, of course, has reserved her right in relation to some of those documents, in respect of which she suggested some redactions. She reserved her right as to coming back to us with redactions for the purposes of the report. So there is a further exercise to be done, but we'll do whatever we can to assist when we send the list of when we send lists of documents to identify those that have been referred to in various hearings.
Thank you very much.
Good. Anything else on that, Mr. Rawat?
No, thank you, Commissioner.
And anything else that we need to consider? Does the hearing next week, the sort of timetable for the hearing next week, which we can consider to some extent, but anything else, Mr. Rawat, other than that?
Not from me, thank you, Commissioner.
Okay. Can I just raise one question before we come on to next week? Mr. Isogil, it's really for you, but also for Mr. Rowe to an extent. We're going to we may have some written submissions on the areas which have been identified, Mr. Isogil. But are there any other legal applications that you propose to make in relation to the COI? I'm not saying there are any, but any need to be made and heard next Wednesday.
None that I'm aware of now, so no.
No, thank you very much, Mr. Isogil. And is that the same response from you, Mr. Rowe?
It is, Commissioner.
Great, thank you very much. Good, thank you. Now, Mr. Rawat, next week, we start at 9 o'clock with the Governor, and we have the questions from, on behalf of the Attorney General. I have an outstanding application from Mr. Hall-Taylor to ask questions of the Governor, really dependent upon the questions that Sir Geoffrey asks him. You may have some questions that arise out of Sir Geoffrey's questions too. We have Mr. Smith-Barclay, who is due to give evidence, and I think he's giving that evidence from the IAC. We have Mr. Frett. We have Mr. Frett, who is giving evidence from the IAC. So, what's the sort of timetable that you envisage?
We still need to finalise the details, but the proposal is that we will begin at 9 o'clock with the Governor. We will have Mr. Smith-Barclay at 11 and Mr. Frett at 12.
Good, and then possibility of Dr. O'Neill Morton. Mr. Isogil is going to come back to us on her availability, and then any oral submissions that I allow to be made on behalf of the elected ministers following any written submissions. And is that the business of the day?
Yes, you have received submissions on the ambit of Section 13 of the Registration of Interest Act, and it may be that you might wish to raise with all the advocates that provision, but that may be just dependent upon further consideration of the written submissions. But our proposal would be that we get all the evidence done, followed then by any legal submissions, and then any matters that arise from the written closing submissions.
Yes, thank you. Just before I come back to the timetable, Mr. Hall-Taylor, are you making any submissions on Section 13 of the Register of Interests Act?
We've been asked to, Commissioner, and that's under consideration. I think the deadline for us providing those is by 4 p.m. on Friday. Certainly the question is under consideration, and if we do have submissions to make, they will be put in writing by that deadline.
Okay, well that's helpful. And then I'll consider the position then next week, and any oral submissions on that will be fairly short. It's a narrow point, and the written submissions are clear. Okay, Mr. Rowett, so that seems to be as far as we can take it in terms of the timetable for next week. I mean, hopefully we can get that timetable finalised onto the website so everybody knows what the timetable is going to be. But I'm not sure that we can take that much further today.
Not today, Commissioner, but we will keep at least those who are present today represent the witnesses that are listed to be called, and so they can inform them of what will happen on the 24th. But other than that, I don't think there's anything further that we need to deal with today.
No, that's very helpful, Mr. Wright. Mr. Risso-Gill, anything else from you? Only,
sir, to clarify this, you said 10 a.m. on Monday. Can I take it that that's for this is for any final submissions from those on behalf of whom I appear? Can I take it that's BVI time on Monday?
All BVI time, Mr. Risso-Gill, yes.
I'm grateful, sir. And finally, as far as Dr. O'Neill Morton is concerned, we have made further inquiries insofar as we've been able to. The position remains, as we are told, that she is not available on Wednesday, the 24th. However, can I simply suggest that we write to you today to explain, if we can, a little further what her position is, and if there is some insurmountable difficulty about Wednesday, what that actually is.
Oh, thank you, Mr. Risso-Gill. That would be much appreciated. Thank you very much. Mr. Rowe, anything else from you for today?
No, Commissioner. Just a thank you for your indulgence. We appreciate it.
No, thank you, Mr. Rowe. And Mr. Hall-Taylor, anything from you?
No, Commissioner. Thank you.
Good. Well, thank you all very much. I think it's been a useful exercise today. I think it has cleared the decks considerably for the hearing next week. And so hopefully next week we will conclude the evidence. We will conclude any oral final submissions, and that will then be the final hearing. I don't think there's anything else that I need to say. What will be apparent from this hearing, but also from the correspondence that has been passing between the COI and in particular the Attorney General and the IRU, is that, as I indicated on the 22nd of October, subject to next week's hearing, evidence is now concluded. We've had some, since the 22nd of October, a couple of affidavits which have been referred to today, which contain new evidence, but this is now a line so far as evidence is concerned. I will only request specific documents, specific evidence, if I think that is necessary for the purposes of the report. But subject to that, next Wednesday's hearing will see the conclusion of the evidence, and I will then continue to prepare the final report with a view to delivering it in the time that has been assigned, namely the 19th of January. That, given the amount of evidence and the amount of issues that have been raised, is a challenge, but it is a challenge which I am determined to meet. Thank you all very much, and that's is now the closure of this hearing, and the next hearing will be next Wednesday at 9 AM. Thank you all very much.